Good afternoon, ladies and gentlemen. On behalf of CESA, I'd like to extend a warm welcome to you, our members, and to those viewers who have also joined us today for the sixth of the webinars in the series on the newly revised CESA Practice Notes. This webinar is entitled The Legal Implications of Design Review, Giving Second Opinions and Expert Technical Advice. So my name is Wally Main. I will be your moderator for this webinar, and I'm a civil engineer occupying the position of Contractual Affairs Manager at CESA. This webinar will be followed by the final CESA webinar on the practice notes on 18 May this year that will deal with the remaining category of professional conduct, as well as dealing with some of the practice notes in depth. You are kindly requested to share news of this event with your colleagues. And I'd like to take this opportunity to bring to your attention the Business of Consulting Engineering Program, or the BCE as we know it, which is an additional resource available to you. The BCE is the flagship of the CESA School of Consulting Engineering and encompasses much of the detail and principles of the CESA Practice Notes. And it is highly recommended that any engineers wishing to advance their careers in the consulting engineering sector should consider registering for this program. And so for details of the BCE program and the many training courses offered by the School of Consulting Engineering, kindly click on the training heading on the CESA website, which is just www.cesa.co.za. I'd also like to inform you that the webinar is being recorded and that the presentations will be available after the webinar on the CESA website, just by clicking on the headings Guidelines, then Presentations, and then CESA Practice Notes Webinars. Before we get started, I'd like to outline some of the house rules for our delegates or you, our viewers. On the taskbar at the bottom of the screen, you will see the chat and the Q&A icons. Please use the chat for any comments you may have and the Q&A for your questions, which we will address in the 15-minute Q&A session at the end of the webinar. I'd like to encourage you to submit any questions you would like to ask and to kindly indicate which of the panelists you would like to answer your questions. To unpack today's topics, we are fortunate to have three distinguished panelists joining us, for which we thank them greatly. They will each deliver their presentations, and at the end of the presentations in total, there will be a question and answer session. Thereafter, the proceedings will end with some closing remarks, and I'd just like to remind the panelists that they have been each allocated 20 minutes for their presentations. The first panelist today is Mr. Charles Celia, who will address us on the topic Guideline for Reviewing Another Consultant's Work. Charles is a professional civil engineer and a technical director at our member firm Jones and Wagner, and he is an active member of the CESA Quality, Risk and Sustainability Committee. Charles is currently the president of GIGSA, which stands for Geosynthetics Interest Group of South Africa. Charles played a major role in the updating and revision of the practice notes. Through his many years spent in the consulting engineering industry, Charles has great experience and knowledge of our industry, and we are lucky to have him share this knowledge with us today. His talk will be based on practice note 56. And I'd like to hand over to Charles at this point. So it's over to you, Charles.
Thank you, Wally, for that kind introduction. So as Wally stated, I'm going to be talking on the guideline for independent review of the designer's work. And Wally did state that the content of my presentation is a summary of the content that's in practice note 56. And I think if you'd like any more information or any further detail of anything I talk about, you're welcome to download this practice notes 56 from the CESA website. It's available to CESA members. Let me start with the contents of my presentation. So I'm going to give a brief introduction and then talk about the purpose of Practice Note 56. I'll go through the different types of review, and then I'll talk about the requirements of review in ISO 9001. Lastly, I will talk on the codes of conduct, both the EXA codes and the CESA codes, and discuss why it's so important to have codes of conduct regarding design review. And then lastly, I'll touch very lightly on the design reviews that are required in South African government frameworks. So as part of an introduction, doing a design review is actually a type of audit. Typically, when one carries out an audit, you withdraw a sample and you review the sample and you make conclusions from that sample and apply them to the full system. But when carrying out a design review, it's a lot more comprehensive than an audit, and one has to review as much documentation as is required in order to come to a point where one can either certify and approve or perhaps give comments on the design. So reviews are often required by clients as holding points before implementation to give confidence of project readiness. So this is typically when the project is working or going from one stage to another, could be from concept stage to detailed design stage. And at that point, there would be a formal review, and there would be approval that it's ready to go into the next stage. Reviews may arise from a dispute from the consultant and the client. The client may be unsatisfied with the design that the consultant has done and would like another opinion, and so appoints another consultant to do the review. The review of one consultant's work by another is an extremely serious matter, and that's why a large portion of this webinar is taken up by the content of the codes of conduct that both EXA and CESA have drafted and require from their members. It's very important to take an ethical stance when reviewing another consultant's work to ensure that we uphold the integrity of the consulting industry. If we look at the purpose of the practice note, it's to provide a guide to the clients for commissioning a review of his consulting engineer's design. And it's also to provide a guide to the independent engineer for conducting the review. And we'll discuss that in more detail as we go along. Okay, let's go through the types of reviews, starting from the top. So a peer review is when one consultant will appoint another consultant to review their design. This may not necessarily be a requirement from the client. It may just be that the consultants would like to increase the confidence levels of all impacted parties on their design. And so they would appoint the other consultants themselves. This is similar to the next circle towards the right, the internal review of outsourced services. In this type of review, a subsection of the work or scope may be subconsulted to another consultant. And when they submit their design, you would have to review it before submitting it to the client. An independent review would be a requirement from the client. And we've talked about different reasons for why that may happen. It may be just unsatisfaction or perhaps part of a dispute process. The next one towards going around clockwise is gate review. That's essentially, as discussed before, when a design is moving from, say, conceptual design to detailed design, and the project readiness of the design needs to be confirmed. Then lastly, design review. This may be when a part of the design, say the conceptual design, is carried out by one consultant, and then the client decides to go out to markets again and tenders the detailed design, and a different consultant is appointed. And then that consultant would be required to review the conceptual design for taking it over to detailed design. Let's take a minute just to discuss the requirements of ISO 9001. So there are various requirements in the standards that are required in order to prove that you have a management system in place that meets the ISO 9001 requirements. So the first of these I'd like to discuss is measurement criteria for acceptance. So essentially, in order to accept a deliverable or a product that you're going to submit to your customer or client, it's important to have a list of criteria to make sure that product or deliverable meets all those criteria before you submit the product. So that's essentially the first part of the review that comes in. Then the second item I'd like to discuss is just the control of processes. So the whole point where the design review takes place is essentially part of the process where the product moves along the system, and essentially it can't move to the next part of the process before it meets all those criteria previously discussed. So at this point, the design review comes in, and the review report, which would be the outcome of that review, would be the documented evidence that one requires as part of the ISO system. So clearly confidence levels would be highly increased if that review is carried out by an independent person. It's not always, doesn't always need to be the case for ISO certification, but it's just a point made. Okay, let's go on to the codes of conduct. As previously said, that it's a very serious matter when a consultant reviews another consultant's work, and it shouldn't be done lightly. And there are a number of criteria or requirements that are required by the Code of Conduct for registered persons, at least under EXA. And the first point I'm going to start with is shown here. Now, the next few slides, which are the extracts from the Codes of Conduct, are quite busy, but we've left the content in so that the presentations can be reviewed after the presentation. So the first point, a consultant may not review the work carried out for a particular client by another registered person, except in these 5 times. Point 1, where the review is carried out for a different client. This could be, say, a typical detail that's used on one site for one client that gets taken over by another client on a different site, and they appoint a different consultant just to make sure that that typical detail suits the site conditions. Point 2, with the prior knowledge of the other registered person. So before one consultant reviews another consultant's design, that original consultant must be notified that their design is going to be reviewed before the review takes place. Point 3, after receipt of notification in writing from the client that the engagement of the other registered person has been terminated. So this could be a situation where the client is completely unsatisfied with the consultant's work and has decided to go out to market possibly and look for a new consultant, that the original consultant would need to be, their appointment would need to be terminated before the new consultant is appointed, especially if the appointment is going to start with the design review. Point 4, where the review is intended for purposes of dispute resolution or legal proceedings, including proceedings arising from these rules. So this is just a case of the review being required to ensure that or to support the client's case in terms of the disputes resolution. And then lastly, for routine or statutory checks, that could be, like we said, the stage gates that are required for clients' normal procedures. Going on to further conditions in the Code of Conduct, a consultant must avoid situations that give rise to a conflict of interest or the potential for such conflict of interest. This is, I think, quite self-explanatory. If there are conflicts of interest, there's a risk that the review may not be as thorough as it should be. Point 2, must give engineering decisions, recommendations, or opinions that are honest, objective, and based on facts. I'm going to come back to this point near the end of this slide. Third point, must ensure that any work approved or certified by them has been reviewed or inspected to the extent necessary to confirm the correctness of the approval. So this goes back to that first point I made, that the design review needs to be comprehensive enough for you to make or for you to certify your opinion on the design. Third last point, may not, unless required by law or by these rules, divulge any information of a confidential nature which they obtained in the exercise of their duties. I think that's self-explanatory. And then second last point, may not maliciously or falsely, whether in practice of their profession or otherwise, knowingly injure the professional reputation or business of any registered person or the reputation of the council. So this goes back to that second point I was saying, that the decisions needs to be based on honest, objective, and based on facts. There shouldn't be a intention to harm the other consultants. That's not the point of the review process. The point of the review process is to find possible ways to improve the design. Then last point, may not improperly supplant or attempt to supplant a registered person in a particular engagement after such registered person has been employed. So I think the point here is that the design review isn't an opportunity for you to advertise yourself as a better consultant than the consultant that you're reviewing. The point is to, as earlier said, find ways to improve the design. I just note the word improperly there, which implies that there are proper ways for one consultant to take over from another. And we have discussed already in earlier parts of the presentation that this may require the earlier consultant's appointment to be terminated, or it could be part of a dispute resolution. Then let's compare it to what is said on the CESA Code of Conduct, and you'll see that there's a lot of overlap between the two, showing the importance of these points and just for emphasis. So the first bullet there, neither carelessly nor intentionally do anything to injure the reputation or business of the others. That's a similar point. Neither directly nor indirectly attempt to take the place of another member already appointed for specific work or after definite steps have been taken towards appointment of such member. Similar points. Not review another consultant's work except with the prior knowledge of that member. Similar points. After receipt of notification from the client that the engagement of such member has been terminated, or where the review is intended for purposes of the court of law. So you can see there's lots of overlap. There are 2 points on here that aren't, but just this first point is similar. Not take over the work of another member on a specific project before notifying the member in question. So yeah, there's lots of overlap between the two, but these last 2 points are CESA specific. So not accept any subcontracted work without the knowledge of the client. So that's just implying that if one consultant appoints another consultant to subconsult part of the scope of works, that should be clearly communicated to the client. And then lastly, one of the driving points that CESA continuously aim for is for all their members to implement and maintain a system of quality management in their practices. Okay, for this last slide, I'm just going to touch on the design reviews that are required. I'm going to specifically talk about the National Treasury Framework for Infrastructure Delivery and Procurement Management, but I'm not going to go into too much detail. Essentially, there are design reviews that are required as stage gates within this framework. Specifically, we've noted here Gate 5 and Gate 6, which is taking the concept design and moving into detailed design, and similarly the detailed design to the tender stage. And that design review is based on, or the focus of the design review is value of money, and they have an emphasis on the 4 E's, which is essentially economy, efficiency, effectiveness, and equity. And if you're interested in this, it is quite a specific part of the practice note. I ask you to just refer to the practice note in more detail. So to conclude, I've got 3 points. Reviews are often required by clients to confirm project readiness to proceed to the next level. Those are those formal stage gate reviews I discussed. Reviews are an essential part of ISO 9001, and if independently done, enhance the confidence levels of the design. And reviewing another consultant's work is a very serious process, and there are guidelines in the codes of conduct of both EXA and CESA. And the point of the codes of conduct is to ensure that we act with ethics, or should I say we act ethically, and ensure that we retain the integrity in our industry. So that's all I have to say. Thanks, Wally. Back over to you.
Thank you, Charles, for an excellent presentation, for so ably presenting on this topic and including practical guidelines and tips in your presentation. And I'm sure these will be valuable for members newly entering our industry or existing members that are about to undertake design checks or about to review another consultant's work. As previously mentioned, the presentation will be available on the CESA website under Guidelines Presentations. And just to assure you that CESA tries hard to empower members with useful information through its practice notes and through webinars such as this one. And I've just been asked to remind you, the delegates, to please post your questions on the Q&A icon, just so that it's easier to identify them. Now we come to the stage where I'd like to introduce the second panelist, who is Sam Varela, who will address us this afternoon on the topic Insurance Implications of Reviewing Another Consultant's Work and Consulting Engineer's Responsibilities in Delict when undertaking design checks. Sam is an admitted attorney and a senior legal risk advisor with CESA affiliate Aon, and is also an active member of the CESA Quality Risk and Sustainability Management Committee. CESA is well known to the CESA membership and was extensively involved from a legal and risk perspective in the recent revision and updating of the CESA Practice Notes. Sam's talk will be based on Practice Note number 8, and at this point I'd like to hand over to you, Sam.
Thank you, Wally, for that very kind introduction, and a very warm welcome to all of our listeners on the call today. It's very nice to see such a large group coming together, and it's an absolute pleasure for me not only to participate, to teach, but also to learn. So thank you for that opportunity, and I'm very excited to deliver a presentation where we're speaking about something that's very close to my heart, risk management in particular, and some of the liability that flows from checking another consultant's design. So I look forward to the interaction afterwards in the Q&A session, so please feel free to reach out to us if you have any specific questions on that. It's also nice to see some of the class from the BCE yesterday joining us. That's wonderful to see that engagement and that interest in the profession. So without further ado, I'm going to take you through my slides. And that really is the liability for checking another consultant's design work. So just an overview of some of the topics I'm going to take us through. First and foremost is what we call delictual liability and the law of delict, the concept of contractual liability, so when you have a written agreement in place with your client, the concept of errors and omissions, negligence in the professional design and consulting space, and then this concept of checking another design or a design check. So to kick off, it's very important for me for consultants to understand the interplay and the difference between what we call the law of contract and the law of delict. And this is incredibly important for me from the risk management side, in the sense that consultants might be under the misconception that just because you don't have a contract in place with your client, that doesn't necessarily mean that you can't be sued and that you can't be held liable for your errors and omissions. And this specifically in the context of checking another consultant's design, which is an incredibly onerous task to take on, for the simple fact that you might miss that error. Members can be held liable for errors in another consultant's or designer's work when they carry out that check. So in the checking of somebody else's work, you then make an error in missing something, and you are then held liable for that error. So where a consultant carries out that check, the relationship between the consultant and the authority or the client that you're being appointed to do the work for is, in a perfect world, what we call contractual in nature. A consultant may also be held delictually liable for losses or damages that are suffered by a third party. And this is very important for me because there's not only the risk exposure in terms of the appointment you have with your client, but there's that additional onerous risk, unlimited liability that you're exposed to when there's a third party that could potentially suffer as a result of your missing that first party's mistake. So you were appointed to come in and do the design review. You missed out on engineer or designer number one's error. You then signed off on that work. You were negligent in that commission, in that sign off, and now there's a third party that suffered a loss as a result of, you know, both parties' negligence while you were actually rendering that professional service. So really, consultants who carry out, you know, sort of surveys or making out of reports, checking in on calculations, will be in the category of what we call possible defendants who might be sued by these innocent third parties who suffered as a result of the negligence, the long tail of that negligence, including future owners that sort of take over that site. Now, what's important there is that there's actually no contractual direct link between the future owners and you as the designer who's now checking or reviewing that design. But there is the liability because somebody is suffering a financial loss reasonably foreseeable by them when rendering that service out. So there is the possibility that somebody down the line might suffer as a result of the negligence and the error or the omission in picking up the fault of another designer, and in turn you are then pulled into that litigation or into that dispute where you are now one of the defendants who have to defend yourself in court or during an arbitration to state why, you know, you should not be held liable for the damages, or at least a portion of the damages. Now, in a perfect world, we would have a contract in place, and in a very perfect world, we'd have a standard form contract in place, like a CESA or a PROXA, or, you know, one of the standard forms that can be used to protect the consultant. But the reality of that situation is that contract is only in place between the party appointing you, being your client, and yourself. And that should clearly dictate and navigate the dispute. Now, when that doesn't happen, so when there is no contract in place and, you know, they are just being appointed, told what to do, there is a scope of services, but there's actually no clear contract in place, then we have the liability that ensues in terms of what we call the common law, which is primarily based on English law in our country. And what that, the crux of that means, and really the message and the take home for that is, just because you don't have a contract with your client or anyone doesn't mean you can't be held liable, and it definitely doesn't mean that you can't be sued. Now, in my research and investigation in updating this practice note and putting together my presentation for today, I dug a little bit deeper and I had discussions and conversations with insurers around where is the line drawn in terms of your liability. So is it actually in a real world possible for you to be sued in terms of this, what we call the law of delict, and does it happen? And their response was really, it definitely can happen, and it definitely does happen. It is a lot harder to prove. So if you're an attorney defending someone who is an innocent third party, or even your client trying to sue the consultant in terms of the law of delict, that's not the case you want, because it is a lot harder to prove. There are what we call these 5 elements of a delict that have to be proven, and I've listed them below there that you can have a look at. These are a lot harder to prove than, just 5 bullet points. You'd have to prove in a court of law that the consultant knew what they were doing was wrong. It was reasonably foreseeable for them to know that their conduct could potentially result in X. And that's very difficult to do. You'd have to prove fault, which is also a very difficult step to prove. And I'm going to take us through a little bit later on in the presentation around this concept or this notion of what we call a duty of care. And a duty of care is primarily established in terms of the contract. It's a little bit harder to prove that duty of care when there's no contract in place. But also what's so important here is that, again, just because you don't have a contract doesn't mean you can't be sued. And very importantly, when you do have a contract in place, that has to be the document used to navigate the dispute. Parties can't sign an agreement where they've got consensus and then deviate from the contract and say, well, you know what, at the end of the day, we're not happy with what we concluded in that agreement, and now we're going to go law of delict. They're bound by the terms and conditions of a valid contract if that was concluded correctly, if it is in fact a valid contract, there was consensus, and all the requirements for conclusion of a valid contract are met, i.e., is it legal, etc. Okay, so another very important slide for me and take home is really, it's so important to obtain clarity from your client on your mandate. It's essential, not only when you're reviewing a design, but really in all situations and all circumstances where you're being appointed in a professional capacity. It's very difficult to defend a consultant whose mandate is not clear and not in writing and not clearly defined. And it also creates unnecessary administrative hurdles for the consultant when they're working on a project. They're being asked to sort of take on these additional responsibilities. They're not being paid for it. They're not aware of the risks involved. So clarity on mandate is essential, not only in this instance, but really in all instances. So you'll remember we spoke about this concept of the common law, and also in terms of most standard forms of agreement, the consultant is required to exercise what we call this reasonable skill, care, and diligence. And that links in very closely with what I speak about on the duty of care. The duty of care that you owe to your client to exercise this reasonable skill, care, and diligence in relation to the specific work undertaken by that consultant. And it's really important that there should be no ambiguity in the instructions that your client is issuing you with. Your terms of reference, again, your TOR, your scope of services should be clearly stated in your contract when you are commissioning or you are being commissioned to check somebody else's work. And again, just going back to Charles' presentation, it's very important to stick to the guidelines on that. There is legislated guidelines, code of practice that dictates when this can happen. And it's important, to adhere to that and to comply with the legislation in that regard. And if an authority or a client simply asks for, and I put this in inverted commas, structural checks to be made or to be conducted, that is a very broad sweeping statement, and the details around that should be clearly defined, and it should be precise in terms of what that means for you. When making a final report or that sort of sign off on drawings or calculations, the authority should be made aware of the items which have not been checked. And again, this message is not only for the instance where there's a design review, but really in any professional appointment. If you're not being appointed to come in and provide a survey on site and soil conditions, or for example, the capacity of the existing foundations to accept an additional load, then that should be put in writing somewhere, and it should be detailed that you weren't appointed to undertake that. I know that it's very difficult to detail everything that you can't do on a project. The paperwork involved in that could be quite extensive, but where you foresee a risk or a possibility of a claim, especially in those instances, make your mandate as clear as possible. Members, in fact, are well advised to record their terms of reference if necessary in a summarized form and actually in their final report or authority to the client to say, this is what I was appointed for and this is all I conducted. Another very important clause for all intents and purposes is the limitation of liability. This is the meat and bones of a contract. It really is providing our consultants with a form of protection in terms of capping of liability. So you may have seen in standard form contracts like CESA, PROXA, FIDIC, NEC, a variety of standard form contracts, there is this capping of liability clause where the parties restrict and they limit the liability of what either of them can be sued for or sue and the duration. And right underneath that, we have a beautiful clause that really does provide that third-party liability protection to the client. And that really says that any claims over and above the limit of liability to third parties will be for the consultant's account. You know, I as the consultant will not accept responsibility for that. But remember, you don't contract with third parties, you contract with your client. So nothing stops a third party from instituting action against you for your participation in their loss. So it's important to have these clauses in place, but keep in mind, you don't contract with third parties and you can't cap your liability with a party you don't contract with. Okay. So I'm just getting to the meat and bones of my presentation, and really something I'm incredibly passionate about, and that's the insurance aspects of this liability. So when it comes down to the fact that you have, as the consultant, have now done everything in accordance with the Code of Good Practice, you've done everything in accordance with the EXA guidelines, you know, you've reviewed your design correctly. What if something goes wrong? What if you are blamed and you are cited in that litigation as a defendant to come to court or arbitration and respond to the allegations that you participated in the outcome of this claim? How is that covered? How does your insurer view that? And what's very important is that, remember, PI is what we call a negligence-based policy. Negligence has to be alleged in order for the policy to be triggered. In the absence of that allegation, the policy is not even triggered. So let's say you as the consultant are called into this dispute and it's alleged that you missed something in your review of your design and you were negligent on that. If you've signed off on an incorrect design, this would be deemed an allegation of negligence and the policy would most likely then be triggered, obviously subject to the other terms and conditions of the policy. However, a big proviso here is that the liability in the scenario would most likely sit with the original designer who had made the initial mistake. So the policy would respond to defend you as the insured on that basis and then would seek a right of recourse against the original, you know, party that had caused those losses. But what's very important is, you know, that costs money. Defending you and responding to the allegations is a time-consuming and costly experience, and not a nice experience for somebody to go through. Rest assured that if you are accused of that negligence, you know, your policy does kick in and it responds subject to the terms and conditions of that policy. Again, in a perfect world, we would have a contract. In a not so perfect world where there's no contract, we then default back onto what we call this delictual liability or law of delict, and claiming in terms of the law of delict. Now, damages in that instance might be much greater than when we do have a contract, because there's no capping of liability. There's no protection there afforded to the consultant. Your client, a third party, could sue you for any amount that they can prove against you in a court of law or at an arbitration. And then you would have to respond to those allegations. Now, those damages and losses would have to be what we call quantified. You know, it is a very lengthy process to come out with that amount. And the courts, I must say, in our country are very fair in how they award damages. And it's not, you know, those amounts are not just put together without ease. but the reality is that you could be held liable to a third party. Yes, you do have that little bit of protection if you have that clause in there, and it's always important to insist on those. Again, just to reiterate, it's very difficult to claim from somebody in terms of the law of delict, but if there is a big claim, you know, lawyers will take those matters on if they believe that you do have a claim. And that's in the instance that you don't have a contract in place with that client or that third party. There is, again, that issue of the hurdle of trying to get over the duty of care that's owed, because in contract we create the duty of care, and it's clear that, you know, there is that liability owed to the client and to the innocent third party. In the absence of the contract, they would have to go that extra step of proving that. But it has been proven in the past, and we know that it is possible. So just to conclude and to wrap up, it's very important to ensure that your terms of reference are very clear in your mandate and what you're being appointed to do. That if you are signing a contract, which is always advisable in this scenario, that your indemnity clauses are in place, that your limit of liability clauses in terms of time, in terms of quantum, and in terms of third-party liability are in place. But it's advised to keep in mind that there are always risks involved in these types of appointment. And that's why it's so important to have brokers that know and understand the industry carefully and that can help you navigate the challenges around this and ensure that you are correctly insured and have the correct risk management processes in place to protect you in the event that something does go wrong. Things do go wrong, human beings do make mistakes, but it's important to have those measures and checks and balances in place. And that's me. It's back over to Wally now.
Thank you, Sam. That was a great presentation. And our members would do well to remember the legal implications and the liabilities that you've spoken of if they ever find themselves in the position of reviewing another consultant's work. And just to remind everyone that the presentations and the webinar will be available on the CESA website. So thank you very much for that. Our final panelist today will be Dr. Nico Vermeulen, who will speak on the topic Second Opinions and Expert Witnesses in relation to claims for damages. Dr. Vermeulen is a geotechnical engineer with 30 years experience, and he is a technical director at member firm Jones & Wagner. He is also a registered engineer with EXA, as well as a chartered engineer in the United Kingdom. He is a fellow of CESA, Institute of Civil Engineers, a member of the ICE in London, as well as being a certified arbitrator and a fellow of the Association of Arbitrators of Southern Africa. So at this point, I'd like to hand over to you, Dr. Vermeulen.
Thank you, Wally, and also good afternoon from my side to all our participants. Let me start off to say that the practice note 89 deals with the role and experiences of a consulting engineer acting as an expert witness or perhaps acting for an insurance claim for the assessors. And this note has been well written and provides really useful and valuable information to any consulting engineer that considers venturing into the field of expert witnessing or acting in this role. And I would greatly recommend that you read the document, work through it, or even if you're already acting or practicing in this field already. However, from my side, what I'd like to do is to share with you rather some of my more practical experiences acting as an expert for a party, and to highlight some of the points that are made in the practice note, but also to share with you possibly some points that are not contained in that document and that are relevant and can possibly pop up during one of these proceedings. And so it's best to be prepared and to know what to expect in such a situation. My talk this afternoon is structured around these 5 points, just to look at the definition of an expert witness, to consider some of the similarities, but more importantly, the differences between court proceedings and what is becoming more and more relevant to the construction and engineering disciplines, and that is alternative dispute resolution, for example, arbitration proceedings. And then we'll have a quick look at some of the activities that an expert gets involved with during the pre-hearing activities. Something that is unique to experts in any legal proceedings, and that is something that is called the meeting of the experts. We'll have a more in-depth look at this meeting and its purpose, and maybe just to also mention that this is the aspect that is not currently addressed in the practice note. And then finally, just what typically happens at a hearing and what role the expert plays there, and how the expert witness differs from, for example, from witnesses of fact. So let's first have a look at the expert witness. That is the consulting engineer that acts as an expert witness in legal proceedings or as for an assessor in an insurance claim. So the most important and first point to make is that as an expert, you are acting on behalf of the adjudicator and not on behalf of your client party. Now that can be a strange concept, and it's kind of against human nature to not defend the party that is actually paying your bill for the services at the end of the day. But it's really important to understand that when you are appointed by a party, you are not appointed in the role of an active defender of his case. In other words, you are not going to go out to prove your party's case at all costs. The role of an expert is actually to assist the adjudicator. And by adjudicator, this could be a high court judge, or it could be an arbitrator in arbitration proceedings, whoever presides over the proceedings. Your role and function is first and foremost to assist that adjudicator in order to form an opinion on the merits of the case, and specifically related to the technical matters or aspects of such a case. So in acting as this role, it requires a certain amount of robustness. We can call it a bit of thick skin. And this also goes against the nature of engineers. Since we are by nature, by our training and by our conditioning, we are cautious in our approach to engineering matters. We are taught to be conservative. We are taught to question our own calculations, as an example, to be uncertain. Those are all qualities that lead, hopefully, to better and more safe design. Now, in a legal dispute, those qualities actually count against you. And so I guess it's only when you reach a certain maturity in your profession that you can turn those uncertainties around into, let's call them certainties, and that you reach a point where you can express an opinion with the amount of confidence that is required to act as a witness, as an expert witness in a legal case or dispute. And I guess that's also part of the reason why engineers, dare I say, generally or typically are hesitant to get involved in expert work. It's certainly not a pleasant experience to enter onto the witness stand and to be badgered by a lawyer from the other side, where your credibility is questioned, and at worst you could be told that it would be better for you to go back to varsity and freshen up on your qualifications. It hardly ever reaches a point such as that, but a certain amount of robustness is certainly a good quality for an expert witness. So if we narrow that down to what aspects define the credibility of an expert, I think from my perspective, it's the 5 points that are listed on the slide. And it starts off with professionalism, and that speaks to your role in acting so that the adjudicator can have confidence in what you are saying, that you are trustworthy, that you are honest, and that you are professional in your conduct. But it also speaks to the other part of being able to keep calm and collected and composed under an attack from an opposing attorney, or even being told by the opposing expert that his opinion is superior to your own opinion. The next part is obvious. It's training, and that means that you must have the appropriate and relevant qualifications in order to speak on a matter. In some respect, your professional registration at CESA is not discipline specific. You are registered as a professional engineer, not a professional mechanical engineer or civil engineer as such. And it's incumbent upon you to act only within the ambit of your training and experience. And this is just then taken to the next level when you act as an expert witness. In other words, dare not express an opinion or an argument if it's not within your fields of training and experience. Practice speaks to the fact that it's not only theoretical knowledge that makes a good expert, but also putting that knowledge to practice. And this can, for example, make it difficult for an academic who has never had the opportunity to practice his discipline in reality or in real life to act as an expert. The two go hand in hand. It's both the training, the qualification side of things, and then putting theory into practice. Experience relates to being on top of things. In other words, to be aware and knowledgeable of the state of the art in your discipline and practice and of the customs that form a part of it. And then finally, it also helps if you are recognized by your peers and that you can show such recognition. For example, being called upon to present keynote lectures at international conferences or similar. And it's certainly not what some might think, the expert being an old, wise person that has been long retired. And no negative against retired engineers. They certainly can make extremely good expert witnesses. But in general, the expert in the prime of their profession are sometimes best suited or qualified for this role, especially in terms of experience and being aware of what current practice and best practice entails. So as I go through the slides today, there may be some comments that seem negative towards the legal field or to lawyers as such, but I just want to make it very clear that I've had the privilege to work with some incredible lawyers on cases for whom I have the highest regard. And so there's no negative sentiment from my side. In fact, I actually believe that it's the duty of a legal person, a legal counsel towards his client to make sure that you as the witness know what you're talking about and that your opinion actually matters. So let's look at some of the significant differences between court proceedings and, say, for example, arbitration. And I think one of the biggest differences that you may not be aware of is that arbitration, when that award is published, it is final. There's no recourse. There's no appeal against the award. It stands as the final award. And it's only under very limited circumstances that a court will be willing to reject an award or set aside an award. So it's a final judgment, if you want to call it that. Whereas a court judgment is more often than not open to appeal. The party that is unhappy with the judgment can sometimes or typically appeal to a higher court for a review of that judgment. So arbitration is final. Court cases are open to appeal. Court cases are also public procedures, so it's open to public scrutiny, or public can either attend the proceeding or read the judgment afterwards. Whereas arbitration, for example, is a private proceeding, not open to the public. And then on a more practical basis, in a court case, the pleadings, all the documentation that are prepared before the hearing is typically done on a minimalist and vague basis. In other words, saying as least as possible and conveying as little as possible of the case and the strengths of the case in preparing all of these documents. And lawyers have become very adept in doing this. In fact, sometimes I think when I've read through the pleadings that it's written in high Vulcan and that only a lawyer and Mr. Spock will be able to understand it. Arbitration pleadings, on the other hand, are purposed to expand on the case, to lay the case out, and in addition to providing all of the facts and what is relied on in the case, also to attach to it all the documentation support that goes with that pleadings. And so when it comes to discovery of documents in court, typically it's a full discovery, which can mean thousands and thousands and thousands of pages of factual evidence that is submitted, whereas in arbitration there's a more flexible approach, and only those documents that are relevant to the issues in dispute are typically discovered. Most importantly for the expert witness, is that in court proceedings or under the court rules, the strict rules of evidence are adhered to, and these are very strict with regard to things like hearsay and what is admissible and inadmissible as evidence in court proceedings. Whereas again, on the other hand, in arbitration proceedings, there can be a more flexible approach to evidence. So moving to the second point, I think I've already dealt with this to some degree. And my opinion on this is that when you're involved in a court proceedings, obviously the uniform rules of the court apply, and there's no doubt about that. But in alternative dispute resolution, I think it's important that the adjudicator and the parties and the experts should not be led by the legal team to adopt the High Court rules for arbitration, for example. So lawyers typically are very comfortable and used to the High Court rules, and they would push for turning the arbitration into a mini court case. And I think there's a risk of losing the benefits of arbitration in speed and cost savings if this happens. And now moving on to your role as expert. So the general rule is that opinion is reserved for the court or for the judge, and that witnesses are only allowed to present factual testimony, and that within the rules of evidence. The expert witness, on the other hand, is allowed to form an opinion on the technical merits of the case. So as it's noted in the slide there, as an engineering expert, you are allowed to express your opinion. You are the only witness in a case that is allowed to express an opinion, generally, but only reserved to the technical merits of the case. You are certainly not allowed to venture into legal opinion, and even more so into the merits of the case overall. In other words, an expression of what you think is right or wrong, or who is right or wrong. So it would serve you good to remember to keep your testimony to the technical aspects of a case. Once the case is on the go, the pre-hearing activities commence, and your role in this part of the proceedings is to assist counsel to prepare for the hearing and to prepare what is referred to as your witness statement and possibly your expert report. And maybe for less informed engineers as regard to the legal system, it's important to note the principles on which our legal system are built, and that's loosely referred to as the rules of natural justice. And what they boil down to is that a court proceeding should obviously be fair and just and equitable and all those good things, but it also means that parties must be allowed to be fully prepared for the hearing. In other words, there's no opportunity for pulling a hat out of a rat during the hearing and surprising everybody with that light bulb moment that we so often see in Hollywood movies or TV series. And so as the expert, you are expected to lay your cards out on the table, and even as experts, your reports and your statements can be distributed simultaneously between experts of opposing parties, whereby each can then give comment on the other. So that by the time that the hearing commences, the parties and the witnesses are well prepared and understand their own case and also the case that has been made against them. Something that I found quite useful in acting as an expert is what I refer to as my angels and demons list. And as you as expert work through the case material and all the discovery documents and the preparations towards the hearing, I find it quite useful to have a list of facts and arguments that are in favor of your own client's case, and those facts and arguments that are against your client's case. And it's important to keep this list updated and to discuss it with your legal counsel. I have had on occasion a situation where I've drafted a list of possible questions that may be asked during the hearing, and then drafted my model answers to those questions. And those questions and answers have on occasion, as I've said, turned our party to rather consider settlement than proceed with the case itself, or alternatively to choose not to call me as a witness in that case, just based on the potential damage that a question like that can have to the case. Then in preparation for the hearing, you will be expected to draft a witness statement and a witness report, or those two might be combined into one report. This means that, or this document can, in some cases, and the modern trend is for judges now to accept this report as your evidence in chief. In other words, your first testimony in the witness stand can be the submission of this report, and you just confirming that that report is your own words and that you stand by the report. This obviously can save quite a lot of time during the hearing. So it's important to take care when drafting the statement. I think it's also very important that that statement is drafted by yourself and written in your own words. There's at the same time also a tendency these days that the witness statements are drafted by the legal team with just minimal input from the expert. And that's a practice that I don't support, and I think is very important. And a trained judge, experienced judge, will know immediately whether your statement was drafted by your attorney or by yourself. So stick to your own words, your own opinion, and your own justification for that opinion. The witness statement then is more of a summary document that spills the beans and gives your opinion on the technical matters of the case, whereas the witness report can be a far more comprehensive document that is filled with all the background information and a review of several documents, including legislation, codes of practice, etc., etc., etc. It then deals with your opinion on each of the issues on which you are qualified to express an opinion, and that is done under the following headings. First of all, you need to define the issue, then express your opinion on that issue, list the facts that are in evidence that support your opinion, and then provide further motivation for such an opinion. And here the rules of evidence can come into play. For example, it is not acceptable for a witness to base his opinion entirely on, for example, a publication that was issued or publicized by authors of which he is not one of them. In other words, you cannot use other researchers' work as the sole justification for your expert opinion. The court or the arbitrator will expect of you to have had personal experience with these matters, and then it would be quite acceptable for you to use publications, textbooks, or other written work in further support of what is your own work and your own opinion. And then lastly, a very well-respected arbitrator from Australia has raised recently some critique on the whole process that involves expert witnesses, and have come up with some recommendations in order to improve the whole system. And his whole point of view is this principle that clients appoint experts as hired guns, in other words, to fight their case for them on their behalf. And some of the reforms that Doug is proposing is that the control of the expert witnesses is passed largely from the clients themselves to the adjudicator. And under these rules, the adjudicator will only call on experts once the issues in dispute have been clarified. In other words, we are clear as to what we are fighting about. And then he will brief the experts in the various disciplines on what is needed for the case. And he will provide the factual evidence on which those experts can work or base their opinion on. And so this takes away some of the variability that can come in when the parties themselves brief their witnesses and makes available evidence documents for them to work with. And I think if we soberly look at Jones's rules, they make a lot of sense, and I think they will improve the whole process for experts in these matters quite significantly. Right, time flies, and I want to move on to some of the parts that are not dealt with in the practice note. And the first, and I think almost the most important role for an expert, happens during what is referred to as the meeting of experts. So this meeting takes place once all of the documentary work is done, the pleadings have been submitted, the discovery has been made, and we're preparing for trial. At this stage, the adjudicator, the judge, or the arbitrator may call on the experts to have what is called the meeting of experts. And this is a meeting that takes place without prejudice. In other words, it's not attended by the attorneys, it's not attended by the party representatives, it's only the experts that come and sit around the table with the intention to talk freely to each other. And the discussions that are held at that meeting stays at the meeting. They are without prejudice and can never be used as evidence in the hearing that follows. So it creates a situation where the experts can talk to each other as professional to professional in an open and honest manner, discussing the merits of each of the technical issues. And the purpose of the meeting is to try and narrow down the issues in dispute. So if the experts decide that they actually agree on point A, they have the same opinion about it, it becomes what is called common cause. And that will basically fall away from and will not come up during the hearing. No evidence or argument will need to be brought to the trial in order to deal with those common cause issues. And so by the end of the meeting of experts, if it's been successful, then hopefully the issues that are still in dispute have been narrowed down to only a few. In some disputes where there are many issues, the person responsible for leading the meeting of experts can make use of what is called a Scot Schedule. So this is just a table that lists all of the issues and eventually gets filled out during the meeting to note those that are common cause, those that are remaining in dispute, and the reasons for the dispute. And often this Scot Schedule is handed in as part of the evidence, and the judge or arbitrator can use this as an agenda to deal with the expert evidence during the hearing. At the end of the meeting, once it's adjourned, a joint report of the experts is compiled, which is basically the minutes of the meeting, and it then lists all of the common cause issues and the issues that remain in dispute. And this report is then issued with prejudice and becomes part of the case evidence. And in my experience, the meeting of expert can often be the turning point in a case. And in many cases, once this meeting has been held and the joint report has been issued, clients may be more inclined to enter into negotiations or settlement discussions than before such a meeting. So I think it's a very helpful procedure or part of the procedure in any dispute resolution. And then finally, at the hearing, there are some significant aspects for the expert during the hearing. One is, for example, that factual witnesses, so not the expert witnesses, the factual witnesses are not allowed to attend the hearing. They are only called into the hearing when they're about to give their testimony, and once they have given their testimony, they then leave the hearing again. In certain circumstances, or more generally than not, the expert witnesses are allowed to attend a greater part or even the full proceedings themselves at the hearing. And the purpose of this is to be better informed of the case and the developments in the case, and certainly the testimony of other witnesses and experts in preparing for your own testimony. Then once you are called to the witness stand, the testimony takes place in three phases. There's your evidence in chief, and as I've said a little bit earlier, your witness statement can actually be submitted to court as your evidence in chief, in which case you will just affirm that those are your own words and that you stand by that report, and may only have to clarify or expand on a few small issues that may be raised by either the adjudicator or the opposing party. Once this is finished, it's then the other team's turn, and opposing attorney will then, or counsel will then, cross-examine you. And this is the most grueling and time-consuming part of any hearing. And this is where the thick skin comes in handy, because that counsel will be out, first of all, to question your credibility, and if not successful, to try and cast doubt on your opinion, your reasons for the opinion, and the facts on which you rely. Once that is done, your own counsel will have another turn in what is called re-examination to try and repair some of the damage caused under cross-examination. And one of the significant differences is that during your evidence in chief, your own counsel cannot ask you leading questions, whereas under cross-examination, opposing counsel is fully permitted to ask leading questions in your cross-examination. All right, and then some things that can happen, not necessarily in court proceedings, but certainly in arbitration, is something that's called hot tubbing or witness conferencing. And the purpose of this is stems from the fact that because of the procedure that is followed during the hearing, an expert witness on a certain discipline or matter can give his evidence, and then the opposing witness will only get an opportunity to refute that evidence or to present his own evidence days or weeks or months later. And that creates a certain discontinuity in the evidence, and it becomes difficult to keep track of all the witnesses and all the experts and of what they said and how they are counted, etc. So to overcome this practicality or practical difficulty, there's a thing called witness conferencing, and basically it is putting up a boxing arena and throwing the witnesses of the one party in one corner and the witnesses of the other party in the other corner and opening up this arena for battle. It's not as bad as it sounds. It's usually led, the questioning, by the adjudicator, who will then pose questions to the experts, and the experts and their counsel can then question and cross-question each other. So it's a more open and flowing procedure to deal with opposing experts' opinion on certain matters, and it happens in real time, so that discontinuity is no longer an issue. In some cases, during the witness conferencing, you as expert may even be given the opportunity to lead questioning of other factual witnesses or expert witnesses. And here it is important to understand, for example, that you cannot ask leading questions. This certainly is a trap that I've personally put my foot into. All right, chess clock arbitration is just another form of proceedings, but where specific time limits are put to each party. So you are allocated a certain block of time, and counsel then has to structure his whole case to fit into that time slot and make sure that the point gets across. So that this typically creates a tight program, but it also leads to a more efficient process and overcomes some of the dilatory actions that can sometimes come into the fray to try and delay the proceedings to get one party to concede or to settle if costs become a huge issue. And then final remark from my side is, during the COVID-19 lockdown, as with engineering, the whole legal profession has also been called upon to adapt, and measures and procedures have now been put into place to actually undertake certainly meetings and many of the pre-hearing activities, but even the hearings themselves by remote means. And you will notice that most of the institutions, for example, arbitration institutions worldwide, now have published procedures of how to deal with remote hearings and to be able to hold hearings and to receive witness statements by remote means. Some of the practicalities that need to be dealt with is the type of software that is used, security and password access, a facility for parties to go into breakout rooms during the proceedings, and then in South Africa also to be sure that there's backup power in the case of load shedding. So that, in brief, is what I would like to share with you today. And as I've said, each of these points are further elaborated in the presentation that will eventually be uploaded onto CESA's website. So thanks, Wally, and over back to you.
Thank you very much, Dr. Vermeulen. That was a very interesting presentation, and it's provided useful guidelines, I think, for our members who intend to become or be an expert witness. And what I particularly enjoyed was that it was well illustrated with practical examples drawn from your own experience. And I'm sure we'll be in touch at some point to help us add those additional points you made to our website. So thank you for that. So as Dr. Vermeulen alluded to, his presentation will be uploaded to the CESA website, and together with practice notes 74 and 89, it will be invaluable to members if they're ever called upon to be expert witnesses. Okay, at this point, I'm going to pose the questions, as many of them as possible, submitted by the delegates to the panelists for their response. Okay, so just kicking off quickly, the questions, first couple were directed to Charles. And what I'll do, I think, is just give Charles a couple of questions, then move on to Sam, and then to Dr. Vermeulen, just so that everyone has a fair chance. So Charles, the first one, first question, please, if you would answer it. Can an independent review also occur in the normal course of an appointment where a client requires verification of design, but even when there is no dispute? For instance, it's a complex design. So.
Yeah, I think that like when I was just describing the different types of design review, it could be part of the scope upfront. When the client is appointing a consultant, they would say, at the end of your design, you will go through a formal design review where another consultant will be appointed. Typically, they could be referred to as a technical review panel or along those lines. So that's one aspect when the consultant knows that he's being appointed and that there's a design review upfront in the scope. Secondly, it may not be detailed in the scope of works, but the design could be, like you said, of a complex nature. And I think then there's nothing wrong with the client, I think, requesting that the design be reviewed. Like I said, it may not be a formal dispute process. It may just be the clients not having a level of confidence in the design or being unsatisfied with what's been submitted, in which case they could have a design review, and the outcome of that review could be, yes, we confirm that this is the level of design that is reasonable, or no, we found that there's these sections that are missing. Wally, sorry, you're on mute.
Sorry about that. Follow-up question: Does a review imply that you are also taken over or accepting some level of professional liability to the client? And if not, how is this handled?
Well, I think that possibly Sam's presentation touched on that after the question was raised. But I think just to elaborate, I think that the consultant who's been appointed to review a design has to be careful in how they draft the contract terms and conditions, and should try and limit their liability through the contract with the client. So yeah, I think that Sam is probably better suited to answer that question than me. But I think that we would hope that the main liability rests with the first consultant, although Sam has said that you do take some liability when you do a design review.
Thank you very much, Charles. Sam, would you like to comment on that?
Sure, and I think you're quite right in alluding to this concept of the liability's got to sit somewhere. So somebody has to be held responsible and pay out for those losses. The biggest misconception is that I was only appointed to conduct the design review, and I'm only responsible for that portion of the work. But the reality is that when you're signing off on something and you're putting your name at the bottom of a document that says, I have checked this and I'm happy with this to go out, and I'm happy for this to be used in construction, and I'm happy for this to be the standard design, then you may be negligent in that act. You may have omitted to pick an error up, and that is negligence. And you can and will be held liable for that negligence. And there's no escaping that liability. Yes, you can cap the liability. Yes, you can have contracts in place. But ultimately, if a court or an arbitrator finds that you, as a reasonable professional with a reasonable level of skill, competencies, qualifications, should have picked the error up because it was so blatantly obvious, and you failed to pick the error up, you might very well be found liable of negligence. Yes, if the ultimate error was of engineer number one, your insurance policy will respond subject to its terms and conditions. It will respond to that claim and then go and seek right of recourse against the actual guilty party. But you will be part of that list of defendants who will then have to spend money on defending yourself and explaining why it's not actually your fault and why it was unreasonable for you to have picked up that mistake. Because if we compare your conduct against any other engineer who may have been appointed to come in and do that design review, is it reasonable for the court or the arbitrator to have said, well, you should have picked that mistake up, and you are negligent in having not picked it up and then gone and signed off on that? So that's really the onerous liability that flows from this sort of checking somebody else's work, because you may very well miss a mistake that really wasn't your mistake, and you now being held liable and being pulled into a nasty court battle or an arbitration that costs a lot of money and takes a lot of time.
Thank you,
Will you
Sam.
permit me to jump in quickly?
Yes, please.
I just want to add on to what was said just now, and in the field of acting as an expert, I think a basic working knowledge of contract law and the law of DLEC is essential. But I've also come to believe that even in the normal practice as a professional engineer, having a basic understanding and knowledge of those two aspects of our law can be incredibly useful. And I think whereas we generally have a better understanding of contract law, it's certainly not the case for the law of DLEC. And that's where liability is not covered by insurance typically, and that's where liability can be uncapped. And so you'd be well advised to just familiarize yourselves with these aspects. Specifically, for example, looking at companies and consulting firms is the aspect of vicarious liability, which falls under DLEC, where a company can be held liable for the actions of its employees.
Thank you, Dr. Vermeulen. Charles, just one more question for you. That what recourse is there if the client or reviewer does not comply with the requirements or the code of conduct that were presented, that you presented for the reviews? And just added a note from all the chat and so forth. The context is inverted commas, backstabbing that takes place, or alleged backstabbing that takes place within the industry. And that means, I suppose, where people criticize other, some firms, consultants criticize other firms.
Yeah, I think that there are regulations that are in place. It's important to remember that EXA is a statutory body, and that their guidelines and the code of conduct and the regulations that are in place are statutory law. So if you are found guilty by EXA of misconduct in terms of breach of the code of conduct, then there are some sanctions that can be applied. And I mean, there does have to be a full proceeding before you're found guilty, but you could be liable for a fine. You could be, your registration could be taken away. So there are serious implications of breaching the code of conduct. However, you do need to go through the full process before you get to that point. And I did follow some of the chats and concerns raised that, there might not be any serious repercussions from reviewing work where you haven't informed the person or not. But it is important to note that by doing so, you are breaching the code of conduct and you can be found guilty.
Okay, thanks, Charles. So just moving on to Sam quickly, because we're running out of time. But Sam, a question that came up a few times is where, question that came up a few times is where consultants are only appointed up to a certain stage of work and then someone else is appointed thereafter. Was that kind of covered in your discussion? So, and the issue of liability, where does it stop and start? So the consultant taking over another stage of work from a previous consultant then assumes liability for their design, but they're not paid to check that design. I think it's on those lines.
Okay, so it wasn't addressed in the presentation, but it's a very important topic, and maybe even another topic for another presentation that we can give, because it's a common question in the industry. And really, the reality is that it's different from reviewing another consultant's design, because you are being appointed to then complete a design. So you are taking over initial work that was done by somebody else, which would technically require you to have some sort of knowledge and review of what they had done, because if it was done incorrectly and you are then building on that and there was initial mistakes made there, you're accepting responsibility for that, because you may be the engineer at the end of the line that's signing off on completion, ultimately accepting responsibility for their entire design. The bad news is that your insurance policy is not going to cover somebody else's mistake. So if it's picked up that, you know, engineer number 1 who was appointed for stage 1 to 4 or whatever it might be, the mistake emanated out of their error that wasn't picked up by you, that puts you in a very tight position and a very difficult position to defend yourself. First of all, it's going to have to be proven that it was initially their mistake. Now, I know from a strategy point of view, a lot of consultants have said, well, can I sort of exclude the liability for, you know, those stages of work and only accept responsibility from the ongoing phases? And the answer is you should always be very clear on your mandate. Always. Your terms of reference, your scope of services should be clear and defined. But if you're the engineer signing off on completion on a design and you don't pick up the fault of somebody else, that's negligence. Now, you could say that you weren't appointed for that review and you weren't appointed to conduct a review. But ultimately, how could you carry on with the balance of the stages on the assumption that the work of the previous engineer was all up to standard and it was all correct and there were no mistakes made in there? So the answer is it's very dangerous to do. There are certain circumstances where it's actually not going to be held, where you're actually not going to have insurance cover for that. And it's incredibly onerous and risky for you, insurable or not. It's not a risk a consultant technically wants to take on, because you are now accepting the responsibility for somebody else's errors and omissions and mistakes that you're just not being afforded the opportunity, the time, the payment to actually pick up on those errors.
Okay, well, thank you so much. That was an excellent answer given in a short time, so thank you for that. And then Dr. Vermeulen, just a last question for you, if you can be a bit brief, because I still have some important things to say. In the chat, there was a comment that experts make terrible witnesses. And I was just wondering, do you suggest some sort of training or orientation or coaching beforehand, or is it available? Thank you.
There certainly are, there is training available. I think both in the South African context, both the Arbitration Foundation of South Africa and the Association of Arbitrators offer coursework certifications that will give training and in some cases actually quite extensive training to engineers that want to act as witnesses and even to the point of being certified to act as an arbitrator. As to the point of making terrible witnesses, I think that the question speaks to something that I alluded to in, that by our nature and our training, we actually are not good witnesses, and it's a mind shift. It's a different way of thinking about things when you act as a witness, to have the necessary confidence in the opinion that you are raising and arguing and defending, as opposed to normal engineering work where conservatism and doubt leads to a better or safer design, hopefully.
Thank you very much, Dr. Vermeulen. So this is the end of the question and answer session, and I hope, I know not all the questions were addressed, but I'd like to inform you that you're welcome to anyone who has burning questions or questions they want answered, can just email me at wally@cesa.co.za and I will make sure that they are answered. And I apologize that we've run out of time, but the quality of the presentations was so good, I didn't feel inclined to cut them short. So thank you for that. We're at the point, colleagues and friends of CESA, we've reached the end of the webinar, and I'd like to thank the panelists for availing of their time and for sharing their knowledge and thoughts with us. And of course, a big thank you to you, our delegates and viewers, for supporting CESA and attending our 6th Practice Note webinar. So just quickly before we close, we'd like to invite you to submit any comments or suggestions you may have regarding our Practice Note webinars. This will enable us to improve them and make them more useful. And you can send your suggestions to me. It's wally@cesa.co.za. And in closing, I'd like to kindly request you to complete the satisfaction survey that will pop up on your screen. The purpose of the survey is to provide us with your satisfaction ratings or feedback, and that will enable us to improve our future webinars. I'm sure what you've been waiting for. Delegates registered with EXA may claim 0.15 CPD points for attending this webinar, and it's as per our webinar attendance list. And for ease of administration, these certificates will be sent to delegates upon their completion of the survey. And just as a very last point, we'd like to ask members to regularly check their spam or junk folders for CESA correspondence in case it has ended up there. We'd also like to request that you whitelist the email addresses that CESA uses. And with that, heartfelt thank you for your attendance and participation. And I'd like to wish you a good day further. So thanks. Bye-bye.